Okay, is it visible clearly? Dr. Abhishek?
Yes, ma'am.
Yeah, you will have to take over because I won't be able to see anything else apart from the screen which I'm sharing.
Yes.
Has Priyanka ma'am joined?
Not yet. Not yet, ma'am.
Yeah, we will just wait for 1-2 minutes for ma'am
Okay.
to join and then we will immediately start.
Okay, ma'am.
So when you want to do next, you just tell me. I will take the next slide
No worries.
in the
No.
presentation. Yeah. Dr. Abhishek, kindly share the message in the groups also.
Yes, ma'am.
Don't forward the link, just share the message.
Yes, ma'am.
So good evening, everyone. Today we are joining for 50th webinar of NIMA OBGY webinar series. And we are continuing with the medical legal series. Today's topic is defense in medical negligence cases. Last webinar was taken on laws and liabilities for BAMS MS practitioners, and this we can consider as continuation or what to do when when we have to defend medical negligence cases. So last webinar was how we can prevent from coming into liability and coming into medical legal cases, and today is defense. So both the topics are very important. I just got a call from Priyanka ma'am. She is joining in 1 minute. Then we'll immediately start.
हमारे नेत्रों स्पष्ट दिख रहा है कि विजय की कामना तुम्हें रावण के लिए नहीं किसी और के लिए है
Dr. Abhishek?
Yes, ma'am.
Yeah, kindly share the link once again to Priyanka ma'am.
Yes.
And meanwhile, I will request all the participants to keep your microphone muted. Also, there is one more instruction. We have to join with our NIMA OBGY registration name, which is written on NIMA OBGY registration certificate and followed by NIMA OBGY registration number. So kindly rename your devices if not done.
Dr. Priyanka ma'am will join within 1 to 2 minutes. Before that, I will start introduction for today's webinar. Shall I start, ma'am? Dr. Prajakta ma'am? Dr. Kulkarni sir, shall I start?
Yes, no problem.
Yes. A very good, just 1 second. Good evening to all. On behalf of NIMA OBGY Central and NIMA Central, I welcome you all to the 58th webinar. Today's topic is Defense in Medical Negligence Cases by Dhananjay Kulkarni sir. Myself, Dr. Abhishek Kokre. I am coordinating today's webinar with co-coordinator Dr. Aarti Nadar. First of all my great pleasure to welcome all the honorable dignitaries present on this virtual dais. I welcome Dr. Kamini Dhiman ma'am, Dr. Priyanka Nakade ma'am, Dr. Vishnu Bhavane sir, Dr. Rajesh Uttane sir. Also further, I would like to welcome all office bearers of the NIMA OBGY and the NIMA Center. Also further, uh, I wholly welcome all the participants attending this webinar. Let me brief everyone with the few instructions to maintain the decorum in today's lecture. Kindly register with the name as written in NIMA OBGY's membership registration certificate followed by NIMA OBGY registration number. Please don't hesitate to put your doubts in a chat box or you can raise your hands. All doubt will be answered after the session. Proceeding further, we are now virtually going to inaugurate this webinar with Lord Dhanvantari Stavan. Everyone can fold their hands and pray to seek blessings for Lord Dhanvantari. नमामि धन्वन्तरिमादिदैवं सुरासुरैर्वन्दितपादपद्मम् लोके जरारुक भयमृत्युनाशनम् दातारमीशं विविधौषधीनाम् शङ्खं चक्रं जलौकां दधतममृतघटं चारुदौर्भिः चतुर्भिः सूक्ष्मस्वच्छान्तिरुद्धं शुकपरिविलसनं मौलिमम्भोजनेत्रं कालाम्भोदोज्ज्वलाङ्गं कटितटविलसत् चारुपीताम्बराढ्यं वन्दे धन्वन्तरिं तं निखिलगदवनं प्रौढदावाग्निनीलं प्रौढदावाग्निनीलं प्रौढदावाग्निनीलम्. May Lord Dhanvantari bless you all with the good health, success and prosperity. Now, I would like to brief everyone about a NIMA OBGY agenda. NIMA OBGY, that is the National Integrated Medical Association, Obstetric and Gynecology Society of India, aims to impact education in supporting and protecting the character, status and interest of the integrated medical profession in practitioner of the Sri Roga and Prasudi Tantra. NIMA OBGY is committed to promote services for the betterment of the health of the community, especially maternal and the child health, prevention of alignments and the disease, their treatment with the integrated approach of Indian medicine with the modern science. Now, I would like to introduce our today's guest speaker, Dr. Dhananjay Kulkarni sir, BAMS, VPAMC Sangli, LLB, Dayanand Law College, Solapur, University rank holder, LLM Bharati Vidyapit Pune, PGD MLS, Symbiosis University Pune, coordinator, Legal Cell NIMA Central Counseling, legal advisor, Ayurveda Teachers Association, delivered hundreds of lectures regarding the legal awareness amongst doctor, medical and law students, panelist in a law firms as a medical legal expert. Welcome the speaker. I welcome you, sir.
Thank you so much. Is it over to me? Shall we start?
Yeah, yes, sir. Just one
Sir.
second. Priyanka ma'am not yet joined.
Uh, I think we'll start with the webinar, and also technical team kindly make Dhananjay sir, me and Dr. Abhishek also co-host. Sir, should I start with the screen sharing again?
Yes, please.
Yeah.
Please.
Yeah, can you see my screen? Just see, I'm starting it now. Is it visible?
Yes,
Yes,
ma'am.
yes.
Yes, sir. Kindly start with the lecture.
Shall we start?
Yes, sir.
Okay.
Yes, please.
To start with, first of all, very good evening to all the dignitaries and colleagues present over here. And hopefully, many of us have not had their dinner yet. Okay. Because post meals legal lectures are best sedatives in the world. So hopefully we have not had
But
yet
we are
dinner.
quite eager to listen you, sir.
Yes, thank you so much. But it makes my job more difficult because first I have to keep you awake, keep myself awake, and then enlighten you with whatever little knowledge I have. So better many of us have not had their dinner yet. To start with, first I would like to thank and congratulate NIMA OBGY Society Central who have raised this platform for awareness of legal knowledge amongst our people, which is most necessary thing nowadays. Because medical profession has been a thankless profession from ages. As we have studied, when the patient is sick, he says that शरीरे जर्जरी भूते व्याधिग्रस्ते कलेबरे औषधि जाह्नवी तोयम वैद्यो नारायणो हरिः. The doctor is like a god and medicine is like a elixir of life. But when anything goes wrong in the hands of medical practitioner or when the treatment is over, the words of patient changes. He says that वैद्यराज नमस्तुभ्यम यमराज सहोदरः यमस्तु हरति प्राणान वैद्य प्राणान धनानि च. That means that doctor takes away life and the money both. So the thankless attitude of patients towards our profession has been coming from ages. But nowadays the things have changed more drastically and more disastrously. The changing laws like Consumer Protection Act and the new disaster has come like BNS Bharatiya Nyaya Sanhita Act Section 106. These are more stringent and dangerous for our profession and have made our profession to profess more difficult. So I thank NIMA OBGY Society Central who have done such a great effort to spread awareness amongst our people so that they will have lesser amount of problems in their practice as far as legal knowledge is concerned. So to start with, next slide please. This is the general disclaimer. The information contained in this academic gathering is for academic purpose only. So no one can sue me for sub judice matters. Information, views, opinions of speaker are their personal perspectives. Organizers are not responsible for the same. So nobody can sue you people for the sub judice matters. Laws, rules, regulations, GRs, case laws or precedents are subject to change from time to time. Please refer to recent laws before applying. And specific defense must be applied or must be used for specific cases here presented are general concepts of defense. This is the general disclaimer. Next slide, please. So why to know the defense? I have gone through the subjects which already have been discussed in the prior meetings or prior conferences or prior our topics. All the topics are regarding the knowledge of law, or what to do or what not to do. What amounts to negligence have been studied properly by you people in the last or prior lectures. But in this lecture, we are going to study what not amounts to negligence, or how to defend the negligence, medical negligence, if anything goes wrong in the hands of us. So why to know the defense? There is an exponential rise in fake medical negligence litigations. Medical litigations have been increased by 20 folds in last 5 years. Please understand, 20 folds. So the legal knowledge is very much necessary to avoid or to combat the condition which will get arised by unfortunate incidences. Then legal knowledge is complicated because 172 GRs, acts, and regulations regulate our practice, and it's impossible for a medical practitioner to know all the things. So legal knowledge is complicated, hence reluctance about legal awareness amongst doctors. This is very common. There is a scarcity of expert medical legal lawyers because my दादाजी used to say कि बैल का दूध एक बार मिल सकता है लेकिन अच्छा वकील नहीं मिल सकता. So there is a scarcity of good lawyers and there is more scarcity of expert medical legal lawyers too. So we have to be aware of certain basic things about defense of our cases. There is a very unfortunate nexus of police, advocates, media which misguide us, because when any case is lodged against us, police comes into action, media approaches us, and then advocates, the three of the things they get together and extort us. So these all factors may lead to harassment and extortion of our doctors. So we must know the basic facts or the basic files of our defense. So the main purpose or gist of the subject of today's lecture is the defense. Next slide, please. What are the building blocks of our defense? See, medical law or the law of medical negligence is not a codified law. There is not a concise book or a code which defines the code of medical negligence. Medical negligence law has been evolved from the precedents or from the decided cases of Supreme Court, High Court, and national and state consumer forums. So the building blocks of defense is the landmark court cases, which we will discuss. And there is a particular defense for every case and circumstances. Still, there are some common principles which are derived from landmark court cases, as I said: rights of medical professionals, duties of patients toward doctors, and proper documentation, which is most important, because all the three are nullified if you are not having any proper documentation. So these are the building blocks of defense. One by one, we will see all those things. And the landmark court cases, we will discuss landmark court cases with the facts of the case. Because if we are not knowing the facts of the case, then we will not be able to judge it, or will not be able to find it appropriate with our cases, unfortunately, if anything happens to us. So we will first start with the landmark court cases, and which we will go through the facts first, and then we'll discuss about the decisions or the defenses of that case. Next slide, please. So we'll go through the landmark cases. Next, please. This is the most important and most basic case of medical negligence, which is known as Bolam versus Prime Hospital Management Committee. It has been decided by the common law or the English court in 1957. And you may have been acquainted with all the cases which we will discuss today. But if they have been already acquainted with you, we'll just brush up the knowledge or add on it. So going through the facts of the Bolam versus Prime Hospital, Mr. Bolam was having some psychiatric ailment. There was some serious depression disorder, and it was decided that he has to be undergone a ECT therapy, means electroconvulsive therapy. So at that particular time, there were two school of thoughts to give ECTs. One school of thought suggested that ECTs must be given with muscle relaxants, and another school of thought was that ECTs must be given without muscle relaxant. The treating doctor of Mr. Bolam was following a school of thought which said that ECTs must be given without muscle relaxation. So, Mr. Bolam was given ECTs without muscle relaxation. But unfortunately, the convulsions or the fits which sustained by the Mr. Bolam was so fulminant that he sustained some fractures, including the fracture to his acetabulum. Eventually, the fracture was diagnosed, treated, and he was sent home. And as every time happens, patient goes home happily. And when he reaches home, he flexes his arms and sues the doctor. So this thing happened in case of Bolam's case. And he sued the doctor, and his contention was, first, that if there were two school of thoughts, then I must have been given, Mr. Bolam must have been given ECTs with muscle relaxant. As because he was not given muscle relaxant, he sustained some serious fractures and sustained some injuries and sufferings. So hospital must pay me the compensation. This was the first contention. The second contention was there was no specialized standard of care delivered by the doctor or rendered by the hospital towards Mr. Bolam. So there was no standard of care, and hence the doctor is negligent, the hospital is negligent, and they must pay me the compensation. The decision was very beautiful decision came by the court, and the court said that whenever there are two or more ways of treatment or ways of treating the patient which are acknowledged or which are established, then doctor has the choice to choose between the way of treatment. This was the first decision. Wherever there is a proper algorithm of treatment or proper protocol of the treatment has been established by peers, by textbooks, or by the training institutes, then if there are one or more ways of treatment, then doctor has a right to choose between the treatment. This was the first decision. And the second decision was the doctor or hospital must not render or may not render best of the standard of care, but it should not render worst of the standard of care. If it is somewhere in between, then it's perfectly all right, and the law doesn't expect a medical professional to render a service which is best of the service. This Bolam's rule has been applied in many of the cases, especially in recent cases. Every case is tested by the Bolam's test, and Bolam's test has two factors. One is of treatment, which has been followed by a doctor, treatment protocol which has been followed by a doctor, and second is standard of care which is reasonable. If these two tests are passed, whatever may be the outcome of the treatment, doctor is not held negligent. So we must put in our mind, or a gist of the case or take home message of this case is that we must follow standard treatment algorithm or standard treatment protocol, and it must be well documented first, and secondly, we must deliver a reasonable standard of care which may not be highest standard of care, or which may not be lowest, which must not be a lowest standard of care. It must be somewhere in between the reasonable standard of care. This is the Bolam versus Prime Hospital, and these two take-home messages, or these two principles which are derived, which are the defenses of our defenses which is used in our cases, Bolam versus Prime Hospital. I think we have understood the case. Next slide, please. Next, another important case is Roe versus Ministry of Health. This is also important case, and it is also decided by a common law, English common law. And this case is decided by the very renowned jurist, Lord Justice Dennings. And it happened in 1954. And the brief facts of the case are, Mr. Roe had some issue in his toe, and it was decided that it has to undergo an operation. And it was necessary to give a lumbar anesthesia to Mr. Roe. And in that particular era, there was a particular modus operandi to give lumbar anesthesia, that the ampule of that lumbar, the liquid of xylocaine was immersed in the liquid of phenol. And the scrub nurse used to take that ampule out of phenol liquid, break it, syringe was filled, and that handed over to the anesthesiologist to inject the injection. This was the modus operandi used at the particular time. And this was used in the case of Mr. Roe. But unfortunately, Mr. Roe undergone a serious problem of permanent paraplegia of both his lower limbs. And operation went very successful, but the anesthesia was not proper, and he never came out of that anesthesia, and he sued the hospital. Lord Justice Dennings gave a very beautiful decision in that case, and the person who is stick to a wheelchair for rest of his life didn't get a single penny or single pound as a compensation in that case. Why this happened? Because as this mishap happened, that hospital underwent an internal inquiry, and that internal inquiry revealed that there were microscopic openings in that ampule of xylocaine, and that phenol was percolated in that xylocaine, and that phenol contaminated xylocaine was injected as a lumbar anesthesia to the Mr. Toe. And as we all know, how phenol it is when it comes to nervous system, it's highly neurotoxic. And there was permanent transaction of spinal cord at the level of injection, and hence it resulted in the permanent paraplegia of both his lower limbs. Lord Justice Dennings gave two principles or two legal doctrines. One is doctrine of unforeseeability. What is unforeseeable? That in the surgeon or a doctor, in his wildest of his dreams, wouldn't imagine that this will happen. First, and secondly, he has followed the standard treatment protocol or standard procedure protocol, and if the thing happens which is unforeseeable or which in wildest of the dreams the ordinary prudent doctor wouldn't imagine, then that for that thing doctor or the hospital is not liable to pay compensation or liable to be guilty. This was the doctrine of unforeseeability. This means for an example, there was in our city there was a GP who used to practice general practice, and he gave injection diclofenac of certain company. I would disclose the name, Laborate company, because this is an academic meeting, so we can disclose the name. There was he gave the injection of Laborate company diclofenac injection. He gave to 50 patients. 45 out of them developed an abscess. 5 of them were bad because they were diabetic. 2 of them succumbed. This was the case. And the case 304A was lodged against the doctor, and he was brought into the court. And we defended the doctor with the doctrine of unforeseeability, because there was a Panchanama over there. And we sent that ampule to the laboratory, and it was concluded that it was highly contaminated and highly infective. So whole batch of that medicine was checked, and it was said that it was found that the whole batch was contaminated, and whole batch was withdrawn by the FDA at that particular time. So doctor was saved because it is the doctrine of unforeseeability. Doctor cannot imagine a company which is approved by an FDA, and he is using that medicine. He is using with regular protocols and aseptic precautions. And if these things happen, which in his wildest of the dreams he wouldn't imagine, then he is not liable to pay compensation or feel guilty about that offense. This is the doctrine of unforeseeability. Next slide, please. The another important doctrine which has been laid down in this case was doctrine of vicarious liability. What is principle of vicarious liability? Then if anything goes wrong by your employee, then that employee is not liable to pay compensation. You as a owner of that hospital are liable to pay compensation. Or if you are working in certain hospital, and if anything goes wrong in your hand, then you are not going to pay the compensation, or you are not going to be a guilty in that case. The hospital under which you are working is liable to pay compensation. This is doctrine of vicarious liability. This principle came from vicarious liability of law of torts, because whenever there is an employee or employer relationship, or there is an agent or principal relationship, then the employee is not liable to pay compensation, but the employer is liable to pay compensation. Therefore, it is deemed that employer is acting through his employee. So the liability of the hospital authorities extend to the fault of doctors and other employees, whether there is employment permanent or temporary or casual or paid or honorary, part-time or full-time, or visiting physicians or surgeons. Every time the hospital has to pay compensation, not the person who is acting on behalf of that hospital or the person who is on duty. This is doctrine of vicarious liability. So the two doctrines, the doctrine of unforeseeability and a doctrine of vicarious liability, have been derived from this case, which is Roe versus Ministry of Health. So I think we have understood the case. Next slide, please. This is a recent case, and this is a very important case too. This is Kusum Sharma and others versus Batra Hospital Medical Research. We'll go through the brief facts of the case. First, Mr. Sharma was an obese patient, had some swelling on his body, was admitted to Dr. Batra's hospital and diagnosed as anasarca, swelling all over the body. CT abdomen was done, and it was found that there were two masses in his abdomen. One was on adrenal gland and one was in abdomen somewhere else. So it was decided that he has to be operated, and the first operation was done for adrenal gland, and the adrenal mass was removed. Unfortunately, it was a benign tumor. Then another operative was done for abdominal mass, and unfortunately, that was a carcinogenic. So he underwent some treatment, and due to some reasons, he developed pancreatitis. Then he developed gluteal abscess, and then he was referred to AIMS Hospital, Delhi. And there, due to that gluteal abscess, he went into septicemia, meningitis, and he succumbed. Then the spouse of that Mr. Sharma, Kusum Sharma, sued the hospital, Dr. Batra's hospital, for negligence. And there were two contentions. First was why there was no anterior side procedure was done, the surgery which was done, why it shouldn't have been done anteriorly. The anterior approach, why not been preferred? This was the first contention. And second contention was the gluteal abscess which happened, why that gluteal abscess happened, and it was due to the surgery that gluteal abscess happened. And due to that gluteal abscess, the patient died due to meningitis. These were the two contentions which were put forward by the spouse of the deceased. So the Indian court gave a very beautiful decision over here. He said that the surgeon has right to choose between the established method of performing certain surgery. If there are two or more ways of surgery, then the surgeon has right to choose between the, according to the facts and circumstances and position of the case, surgeon has right whether how to perform a surgery, by what method has to perform surgery, and at what time he has to perform the surgery. And furthermore, the court said that medicine is not an exact science involving precision, and every surgical operation involves uncalculated risk. Merely because the complication has ensured, it doesn't mean that the hospital or doctor was guilty of negligence. It's a very important statement. And second thing, when there was gluteal abscess was due to his obesity and bed sources. There was nothing to do about the surgery. The surgery was not direct responsible for that gluteal abscess nor for the meningitis which subsequently happened. So to prove the medical negligence per se, there should be an established direct connection with act or omission which allegedly caused the damage and the damage itself. So complainants have failed to prove connection or linkage between the first surgery and the cause of death, hence negligence cannot be proved. So whenever there is an allegation of any negligence, we can give the defense that, see, what happens when anything happens to our hospital, patient is annoyed and patient runs to another hospital. And then patient runs to third hospital and fourth, and so goes on. So the primary hospital, if unfortunately, hopefully not, but if the primary hospital is of ours, or we are the first surgeon or first doctor who is treating the patient, then we are not directly responsible to whatever has happened in between. So we cannot establish a direct linkage between the first thing which has happened and the end result of that last hospital which has been where the patient succumbed, or at home the patient succumbed. So we can disconnect the chain between it, because there is a precedent, there is a Supreme Court who says that there must be a direct linkage between the alleged negligence act or omission and the result of that negligence, alleged result of that negligence. So the gist of the case is, first, the surgeon has right to choose between the modes of surgery, and second is there must be a direct linkage between the alleged act of the negligence and the result of negligence. I think we have understood the case. We'll go for the next case. Next, please. This is also a very important case and recent case, M. Kocher versus Ipsita Seal. This is National Consumer Forum case. So the brief facts of the case that Mrs. Ipsita Seal was a woman having first she was pregnant, and unfortunately it was a cervical pregnancy. No, it was an ectopic pregnancy, and her tube was removed, left tube was removed. And fortunately, she was pregnant again, but unfortunately, it was also an ectopic pregnancy. But this time, her tube was saved, but the pregnancy was removed. Then she has to undergo IVF treatment for next pregnancy, and she went for the treatment in the hospital, State Gangaram Hospital at Delhi, and which was failed. The IVF was failed many times. So her allegations were, first, that doctor assured me of success of IVF and hence charged me multiple times. This was the first allegation or first contention. The second contention was that the semen analysis was done elsewhere and it was not done with aseptic precautions, and hence I suffered infections and due to which the IVF failed. These were her contentions. The court observed everything, heard both sides, and said that there is no guarantee of success in any case. So there is no cure, no success is not negligence. If you are not cured, then you cannot claim a negligence. This is first thing. And secondly, the court said that even if the antibiotics were prescribed in that case, that doesn't mean that there was an infection, because in empirical level, on empirical ground, antibiotics are usually prescribed, and there was no specific ground. There were recorded statements of AIMS doctors also, and there was no any evidence of infection which caused the IVF failure. And residing on the case of this case, she had only one tube remaining, only one tube which was patent, and there was very least chance of further what we say possibility of natural pregnancy. So this was not the last and least chance that caused her irreparable damages. So she can have another IVF cycles and she can have the pregnancy in future. So there is no cure, no success. That doesn't mean that doctor is negligent first. And the allegation of infection caused the failure is a false allegation, and court has reprimanded or given fined that person, Ispita Seal, who was the victim in that case, that he for filing a false case on doctor. This is very important. If the gist of the case is, if there is no cure or no success, is never a negligence unless and until you are following a standard treatment protocol, unless and until you are following a standard treatment algorithm. If there is no cure or no success, that patient cannot claim that you are a negligent person. So I think you might have understood the case. Next case, please. I think we all have been very much acquainted with the case. This is very important, very famous, and a very backbone of Indian medical negligence cases, Dr. Jacob Matthews versus State of Punjab. Even if we are acquainted with the case or knowing of the case, I will reiterate the case, fact of the case. Dr. Jacob Matthews versus State of Punjab is a very important case. And if anybody wants to study the medical negligence, law of medical negligence, I would suggest that go to internet, download Dr. Jacob Matthews versus State of Punjab. A 17-page judgment will come. And this is gist of all the medical negligence knowledge all over the India. And this is very important judgment which has been derived by Chief Justice of India. And this is Dr. Jacob Matthews versus State of Punjab. I will go through brief facts of the case. There was a patient who had an end ailment and who was admitted to Dr. Jacob Matthews Hospital. And he had some terminal cancer, but the relatives of that patient were very influential, and they said that Dr. Jacob Matthews said to Dr. Jacob Matthews, let the patient be in the hospital, let the patient die in the hospital. We don't want patient to get our home. Dr. Jacob Matthews says, all right, no problem, he be in the hospital. And one fine day, what happened? Patient went into gasping. Then the nurse came with an oxygen cylinder. And as many times happens, oxygen cylinder was empty. Then she rushed and get another oxygen cylinder. Meanwhile, Dr. Jacob Matthews also came in, but they could not save the patient. Then the relatives who were saying that let the patient be in the hospital, let the patient die in the hospital, created hangama in the hospital. And they went into extent to file a criminal case against Dr. Jacob Matthews. And police, as the relatives were influential and had some political background, the police lodged the case against Dr. Jacob Matthews with Section 304A, causing death with negligence, without knowledge, without intention. So Dr. Jacob Matthews plead in the lower courts that I have done criminally wrong, that I have been dragged into a criminal court, because if the patient would have been at home, there would have been no oxygen cylinder, there would have been no Dr. Jacob Matthews. He had to die anyhow. But why I have been criminally charged, or why I have been criminally dragged into this case? Court said nothing doing. Dr. Jacob Matthews' charges were framed and they were retained. He went to the High Court, nothing happened. Then he went to the Supreme Court. And in the Supreme Court, the very beautiful judgment was given by Chief Justice of India, Justice Lahoti. He just bent that decision and said that, first, criminal liability under Section 304A Indian Penal Code, it is necessary that death should have been the direct result of the negligent, irrational negligent act. This is first. Second, the degree of negligence required should be gross, and it should not be just a simple sort of negligence. It should be a gross negligence. What is gross negligence? See, if one person is, assume I'm a surgeon and I'm going to have an operation today, and I'm dead drunk. I'm that drunk that I cannot walk properly also, and I committed the operation and the patient dies, then this is a gross negligence. Or an ophthalmic surgeon doing the abdominal surgery is a gross negligence. So the degree of negligence required should be gross to drag a doctor into a criminal matter. So who will decide the negligence is gross or not? Then there must be a committee of that particular specialty which will decide that the negligence is gross or not, and the criminal charges must be imposed on a doctor or not. These are the 2 points, that the degree of negligence must be gross, and degree of negligence must be decided by expert committee established by a civil hospital or a teaching hospital of nearest area. Second, to impose a criminal liability under Section 304A per se, there must be a direct linkage between death of a patient and act of a doctor. As I said earlier, there must be a direct linkage. These are the 2 points. Next slide, please. And if any patient goes with a private complaint to the court, then it will not be entertained in the face of evidence unless and until a credible opinion from government committee comes. Unless and until there is a credible opinion, no FIR shall be lodged against a doctor. So whenever any thing happens or any call comes from the police station regarding Section 304A, you can fearlessly go to that police station, because FIR cannot be lodged unless and until the expert committee report comes against you. This is the very important, very what we say, backbone of criminal negligence as far as Indian medical law is concerned. So we must have the copy of this judgment, and if a police harasses us, or if they force us that or they blackmail us that the case is going to lodged against us, then just show the case and tell them you cannot have a police case against us unless and until the expert committee report has come. This is the case. I think we have understood the case. We'll go for the next case. Next is very important case, and this is the application of Dr. Jacob Matthews case or guidelines given by Supreme Court in Dr. Jacob Matthews case. This is Martin D'Souza versus Mohammed Ishfaq. Mohammed Ishfaq was a patient who was a 75 years old patient, had some UTI, urinary tract infections, and he was administered certain injections. Or gentamicin, and due to those continuous injections, he sustained his auditory nerve issue. So he sued the doctor and he said that I have problem due to this treatment. I have auditory nerve issue and I have to be paid 5 lakh rupees as compensation. At the age of 75, what he was going to hear, I don't know. but he was asked, he was said, his contention was, I have to be paid 5 lakh rupees as compensation because my auditory nerve has been damaged. So the Supreme Court in this case extended the guidelines given in Jacob Matthews case to criminal case to civil case. The court says that whenever complaint is received against a doctor or hospital by consumer fora also, or a criminal court also, the consumer forum or criminal court should first refer the matter to competent doctor or committee of doctors specialized in that field relating to which medical negligence is attributed, and only after the doctor or committee reports that there is a prima facie case of medical negligence should notice, then notice should be issued to the concerned hospital doctor. Even the notice should also been banned by the Supreme Court. You should send the notice to the doctor also after getting the committee report, expert committee report, that doctor is prima facie negligent in this case. Even in civil cases, even in consumer fora cases also, expert committee report is necessary, is said by the Supreme Court. Practically it never happens. Usually we get the notices, but we can have our defense that expert committee report should be acknowledged with the notice. This is the first thing. Next slide please. Second and most important observation what Supreme Court has observed is that if a police officer arrests or harasses a doctor, unless the facts clearly come within the parameters laid down in Jacob Matthews case, means expert committee report is not yet come, and if police harasses us, the policemen will themselves have to face the action. We can show this judgment and suspend the police officer if any police officer harasses us regarding the medical negligence case. This is very important case, and everyone must have this copy of this case, Mohammad Ishfaq versus Dr. Mohammad Ishfaq case. Everyone must have the copy of this case, and I will give the brief literature of these cases. Martin F. D'Souza versus Mohammad Ishfaq is the case, and I will give every literature of every case we have discussed today to Dr. Priyanka madam, and everyone will have those cases with in their hands. Next case please. This is the most critical scenario. I think Advocate Mishra has already discussed this BNS 2023 Act and Section 106, that causing death by negligence, where whoever causes death by negligence is punishable which may extend to 5 years, and they have changed the registered medical practitioner definition, and we integrated practitioners, even dentists, homeopaths, they never come under that definition of registered medical practitioners. So if anything happens wrong by our hands, then we will be punished with 5 years imprisonment. And if anything happens wrong by the MBBS doctor, or which has been recognized under the National Medical Commission Act 2019, that means MBBS doctor, then it may extend up to 2 years. That means if anything happens wrong by our hands, patient dies with our hands, then we will have a non-bailable offense. On the other hand, if anything happens wrong by the hands of MBBS doctor, then it is a bailable offense. This is a clear-cut discrimination done by honorable government, and we are fighting in court of law. We have filed a writ petition, and we are doing our best to rectify it. But if anything happens in between, we have a defense. Next slide, please. The defense is well-known case of Mukhtar Chand versus State of Punjab, and it has been clear-cut said by the Supreme Court. It becomes necessary for rule-making authority to define the expression registered medical practitioner for the purpose of the Act and rules. And Rule 2EE does no more than define that expression, which is within the scope of Section 33I as well as Section 33(2)E. That means there is another definition of registered medical practitioners which has been priorly made by the Act and which has been endorsed by the Supreme Court in the Mukhtar Chand case. And we are also coming under the ambit of registered medical practitioner. At least we can argue in the court of law that this can also must be considered, because Rule 2EE3, next slide please, clearly says that registered medical practitioner defined under Rule 2EE3 clearly says that we have right to practice modern medicine if we have been given any privilege by the state government, and we also come under the ambit of registered medical practitioner. This is a titulary defense because it is a codified law. BNS is a codified law, but we can argue in the court of law that we are also eligible to be a registered medical practitioner, and we can be also coming under the ambit of RMPs. This is the defense. Next slide, please. There are certain other important points of defense. We'll go through them. First one. Next, please. And these points are which not amounts to negligence. These points will reiterate what not amounts to negligence. Refusal to attend the patient in certain conditions is not a negligence. The doctor has a right to refuse to attend the patient when he is not available or out of station, treating other patients, the patient belongs to other expertise, or working hours are over. Hence, the doctor has right to refuse the patient in certain conditions, but there is a certain proviso to that. It is pertinent to mention that these excuses are not valid in emergencies, but you can refuse the patient. Yes, surely you can refuse the patient in certain conditions. Next slide, please. Very important thing is burden of proof. To prove a negligence is on the shoulder of complainant, means patient. Then whenever a notice comes to you regarding any medical negligence, you just don't have to horrify, because it is his duty to prove a negligence. It is not our duty to disprove the negligence, because as per the Honorable Court's opinion in Calcutta Medical Research Institute versus Vimlesh Chatterjee and others, it has been said that the onus of proving negligence and the resultant deficiency in service is clearly on the complainant. So he has to prove the negligence has happened, and we have to rebut, or we have to just cut down the arguments and contentions done by the patient side. Next slide, please. If there is a contributory negligence on the part of patient, then doctor is not liable. If the patient does not follow prescription, referral, investigations, or any other advice given by doctor, then doctor is not responsible for adversities, provided that the given advice is available on record. So documentation is very important. And whenever a patient shows a prescription in court of law, then you must ask for a receipt of the medical where the medicine was purchased. Because if the patient shows the prescription, that doesn't mean that he has purchased that medicine or he has consumed that medicine. Whenever a patient flies a prescription of yours in the court of law that I have taken these medicines and I have, regardless of taking these medicines, I have not got any relief, you must anywhere ask for the receipts of medical shop that the medicines were already purchased. And whenever there is a referring letter we give to the patient, get a carbon copy of that patient or another copy of the that letter to you, and get a signature or thumb impression of the patient and retain it to your side. Any investigation you suggest which is outside of your clinic or hospital, then you must also retain a copy signed by a patient of that investigation request letter. Or if there is any specific advice given to the patient, then you must give it in writing, keep it a copy of that advice to you, and get a signature of thumb impression of that patient, so that it will be easier for you to prove that we have been advised, the patient has been advised by us for a certain things, but patient has not complied, or patient has not done that what he was supposed to do or he was advised to do. So if there is a contributing negligence on the part of patient, then we are not completely liable to pay compensation or being guilty of negligence. Next slide, please. Next is a legal doctrine which is less indicata, that is limitation period. No case of medical negligence stands against the doctor after limitation period of 2 years is over, provided that this period starts when the patient comes to know about the effect of his injury due to alleged medical negligence. So there are two parts. If the cause of action arose before 2 years, then there is no locus standi if the patient complains against us in the court of law. If the period of 2 years is over, but when period of 2 years will start, then the patient will understand or know about the negligence or ill effects of our treatment or procedure, then at that particular time, from that particular time, the 2 years count is done, and after 2 years, if he lodges a complaint against us, it is not tenable in the court of law. This is doctrine of res indicata. Next slide, please. This is doctrine of res judicata. If the subject matter of the case is already been decided in court, then such case is not tangible in court of law. Next slide, please. Next doctrine is novus actus interveniens, means act of God. Then if any mishap happens beyond human control, then doctor is not liable. For an example, if earthquake comes while you are operating a patient, and if any mishap happens, then you are not liable. If the grid fails and the electricity supply is off and the patient on ventilator dies, then you may not be liable. Ambulance is stuck in traffic, causes death of the patient, or non-availability electricity due to natural calamity. These all are decided cases. These are not only examples, these are decided cases, and there where novus actus interveniens or act of God doctrine is applied. Next, defense. Next, please. Next is very important, instrumental defect. If any instrument fails and any injury happens to the patient due to malfunction of any medical device, you may not be liable. When you are not liable, then that instrument must be in a good condition. I'm getting an echo.
That is maybe due to someone's iPhone, I think. Dr. Prajakta.
Yes, ma'am.
Doctor, I think unmute everyone because this echo is causing, I think, from
Yes.
S. Rana, Dr. S. Rana.
Yeah, I am actually sharing the screen, so won't be able to do that. Dr. Abhishek, could you do it?
Yes, the instrument must be in proper condition and the AMC record of that instrument must be with you. Then that instrumental defect will not make you pay compensation or make you liable for medical negligence. Next slide, please. Act in emergency. Whenever there is an act in emergency, then medical negligence is not proved. For an example, if there is a rib fracture during resuscitation procedure, then the doctor is not liable for doing resuscitation because that was the utmost required thing, and that is the collateral thing or collateral damages which happen due to act in emergency. Then you are not liable to be punished, or you are not liable to be guilty of medical negligence, whichever act is done in emergencies. Next slide, please. Voluntary not fit injuria. To a willing person, no injury is done, because a patient wants to do certain thing, and if any known side effect happens for that treatment or for that procedure, then doctor is not liable for that side effect. When a doctor treats a patient with well-informed consent, then the doctor is not liable, provided that it is done with good intention for welfare of the patient and with due care and diligence. That is, for an example, radiation burn during cancer treatment cannot be held as a negligence because it is a known side effect of that treatment, and already the patient is well known about that side effect due to informed consent. So to a willing person, no injury is done, there is no negligence. Next slide, please. In certain conditions, even death of the patient is not negligence. It is settled case of Supreme Court, Dr. Harish Kumar Khurana versus Joginder Singh, and certain other cases also, that the Supreme Court has said that even death of the patient on the face of it cannot be considered as a medical negligence. Why? Because standard treatment protocol or standard treatment algorithm was followed, and whatever may be the end result of that treatment, even if the patient is dead, but even in that case also, doctor is not held liable or not held negligent, because standard treatment protocol, standard treatment algorithm was followed and well documented, most importantly. Next slide, please. If the failure is recognized and told to the patient, failure is not negligence. See, every treatment cannot assure as a 100% cure, but if the percentage of failure has been recognized by the peers and it is already told to patient, that failure is not negligence. The probability of failure is recognized and it is conveyed to the patient accordingly, And if the failure happens as per the probability, then there is no negligence. There is an example, well-known example of Santra's case. We all may be knowing the Santra versus State of Haryana case. I will briefly go through the facts of that case. Mrs. Santra was coming from the family of stonemasons, which used to break the stones and which reside beside the road in a tent. She was amongst that society, and she had 9 children in that condition also. And one fine day, both the husband and wife decided that it's enough now. We'll have to go to the hospital and we'll do tube ligation. And the tubectomy operative was done. She came to home, and after 3 months, again she had no menses. She went to government hospital and told the doctor that I have amenorrhea and please check me. There usually that happens that usually nurses said that तेरे में खून की कमी है etc. and already तेरा operation हो चुका है, कुछ नहीं है, घर जा. Then after 4 more months, she saw that something is happening which happened 9 times ago. So she again went to hospital. My abdomen is getting bigger and bigger, and I think this is something else. So they did the USG, and it was found that she was pregnant again. And some NGO came into action and they sued the government hospital for negligence as there was a tubectomy failure. The court held that there is a negligence per se in this case because we know that tube ligation has tubectomy operative has a certain amount of failure probability. But why didn't you tell the patient? Because it is recognized. No problem. It is recognized. Failure is recognized. But why didn't you tell the patient that in certain conditions also, in certain cases also, this operative can be failed and you may get pregnant, and you have not told the patient that about the failure. So the doctor is held guilty. The government was in fact held guilty, and the son which was born, the government was given order that until that boy attains his puberty or he becomes an adult, 18 years of age, the whole what we say expenses of that boy, education and all, will be bared by government. So the boy was named after that government, and boy's name was Haryana. This was a very famous case. If the failure is recognized and told to the patient, failure is not negligence. Next slide, please. Res ipsa loquitur, that thing speaks itself. See, whenever we go in the court of law, the verbal evidence what we give is a secondary evidence. The primary evidence is documentary evidence. So the importance of documentation is utmost in defense of medical negligence cases. Documentary evidence is always on upper footing than oral evidence. Unfortunately, our fraternity is reluctant to keep proper medical records. We have to be vigilant and careful in maintaining OPD, IPD records, consents, referrals, and discharge papers, and especially daily round details. Daily only seen by signature is not important. Daily round details by the hands of treating doctor is very important. He is dictating and his houseman is writing something else. Every time this happens, in every case this happens. The daily notes, round notes are not being kept properly, and this is the main problem, main issue in defending a doctor, because we cannot rectify them because already they have been submitted to the court and we cannot rectify them afterwards. And if we will rectify them, we are giving a false evidence, and false evidence is itself an evidence against us. So we cannot rectify or fabricate it afterwards. So get some time, don't be in hurry, and put proper notes, put proper material in that notes, so that we will not be in any trouble afterwards. This is res ipsa loquitur, things speaks itself. Documentary evidence is very primary and very important, at most necessary. So it must be properly. Excuse me, the screen share has ended.
Dr. Prajakta? Dr. Prajakta?
Yes, ma'am.
Why the screen sharing has been...
I was actually, someone removed me from the meeting with me. I have to rejoin. I will just do the screen sharing again.
No problem, ma'am. So the proper informed consent is very necessary. I think one lecture was there on informed consent, and we all are well acquainted with the necessary prerequisites of the informed consent. Even video consent is also good option because the competency and details of all the investigation treatment are also being covered in video consent. But before taking a video consent, we must take a consent of video, that your video is being taken by us and for the consent, and that particular consent, before that video should be taken, and then video consent should be taken. Even if documentary evidence has upper footing, video consent is also acceptable and admissible in court of law, and it can also be done. So proper informed consent is very important, and his voluntary participation of the patient is endorsed by the proper informed consent. And I think we all are already been flourished with the knowledge regarding informed consent. And blanket consent should not be taken anytime. Blanket consent has no value in court. Every procedure, every treatment has certain special ill effects and effects. So separate consent for each procedure should be taken. Next. So I spoke about proper informed consent. Next slide, please. Timely inform to police. This is very important. So whenever we suspect or whenever we smell any foul, any offense, it is our legal duty to inform police about that, because failing of which section 202 of IPC and section 39 of CRPC are attracted, and even more serious consequences where there is a strict enactments like POCSO. Because if we are failing to inform police regarding any legalities of POCSO or any offense of POCSO, then we become the co-accused in that case. It's a very serious thing, because it has no bail. Even anticipatory bail is exceptionally proceeded in High Court. So it's very difficult. So whenever we think anything bad about the POCSO law, then we must inform the police, because there is no cross of that young child. So if he says that I have told the doctor about the offense, and usually the police feeds that child to say that you have told the doctor about that offense, then you become the co-accused in that case. So whenever you smell foul anything, then you just inform the police. And how to inform the police? We cannot just phone call a police and say that this and happened, and I have certain kind of intimidation or certain kind of possibility that there is an offense happening. So you just do one thing. You just go to the Google and ask for the email ID of superintendent of police of your city, and just mail that police of superintendent of police. Hardly anybody sees that mail, firstly. Second, you have a documentary evidence that you have already told the police about that, because phone call also is not a proper evidence that you have told the police about that offense. So just mail it. You will not have any problem, and you will have a documentary evidence that you have told the police about the apprehended offense. So if we have timely informed the police machinery about suspicious offense, it is our great defense. Next slide, please. So how to avoid litigation? We all know that proper attention to the patient. If you want proper attention, if you don't want to give proper attention, at least pretend to be. Proper attention to the patient, calm and polite behavior, precise communication, proper documentation, updated knowledge, touch of humanity, at least pretend to be. Indemnity insurance, Dr. Mishra has already discussed that. Legal assistance in time, very important. When you have already submitted the documents, and if you are coming to any medical legal expert about that, he cannot do anything for anything. He can do, but it's very difficult to prove or disprove certain things if the documents have been already submitted. legal assistance in time, and unity of fraternity that we all are doing. And I especially congratulate NIMA OBGY Society Central. They have united our fraternity to such an extent that so many people are now listening to us and getting proper legal knowledge and getting proper information about it. So I especially thank NIMA OBGY Society for giving me chance to speak in front of such a beautiful crowd. And thank you so much for giving me opportunity. Thank you so much. If there are any questions, they are welcome.
Wonderful session, sir. Actually, I would like to say that this was one of our brilliant session, because small thing that we do not take so much seriously, but these are very important in during our practices also. So I think one should implement that things. And means in my thought, think I always used to say that this medical legal subject that should be included in our syllabus also. When we talk about our PGs, second year or a final year, they should include this subject in their syllabus, so that during the learning period also we should have the basic knowledge of this medical legal aspects. So I will recommend such things, and I will try to put this in front of Ayush, that the medical legal should be on our priority basis for all the clinical subjects.
Truly said, man, truly. Because what is happening nowadays, that it has been what we say, law has been a sector of falsehood. It's very difficult to defend a true person in the court of law. I will reiterate a share written by Dr. Rahat Indori sir, late Dr. Rahat Indori sir. What is the judiciary? He has always defined in a share. What is judiciary? Dr. Rahat Indori says that झूठों ने झूठों से कहा है सच बोलो, झूठों ने झूठों से कहा है सच बोलो, सरकारी ऐलान हुआ है कि सच बोलो, मुकदमे में बैठी झूठों की मंडी है, मुकदमे में बैठी झूठों की मंडी है, और दरवाजे पे लिखा है सच बोलो.
क्या बात है?
This is the clear cut scenario of today's time, where the falsehood is running everywhere. So if at all we are having resources, but we must have at least some sort of legal knowledge, so that some things can be some things can be fought upon. Thank you, madam. Thank you.
Yeah, thank you so much, sir. Prajakta, you can carry with the question.
Yes, sure, ma'am. Dr. Aarti, you can proceed with the question and answers.
Yes, ma'am. Thank you so much, sir, for this wonderful session. It was very informative, not only for PGs or practitioners, it was also useful for UG students who will be like practicing after only completing BMS. So thank you so much. I request Prajakta ma'am just to ask the surprise question. Prajakta ma'am?
We don't have any surprise question, dear. Carry with the Q&A, dear.
So we have question. So what is the procedure in court if a patient sues in our court if any negligent case occurs?
Pardon me, I have not understood what I have said.
If any patient complains against a doctor, so what is the legal procedure in court for the doctors to go forward to fight against
When
it?
any patient sues a doctor, what is the procedure for the doctor to follow?
Yeah. In the court.
In the court. You see, there are many courts where doctor can be sued. First is criminal court, another is civil court, third is consumer court, fourth is human rights court, and fifth is council. So in these 5 sectors, patient can drag us. So everywhere the procedural law is different. In civil court, there is a civil procedure code which has to be followed. In criminal court, there is a criminal procedure code which has to be followed. In consumer court, there is a different law, different procedural law. And in human rights and councils, there is a separate code. So in which court you have been dragged into, that depends on that court, that which procedure should be followed. If we are already we are always worried about the criminal cases because this is the only thing which apprehends us, because the end result of it is going behind the bars. So it dissolves or devours our whole goodwill, money. The life is devoured. So I'll talk about the criminal cases. When any criminal case is lodged against us, especially serious cases like Section 304 Part 2 or Section 304A, then the first thing is we have to wait till the expert committee report comes. If expert committee report comes in our adversities and the FIR is lodged, then we have to go for the bail. If the offense is bailable, then we'll get a bail in police station itself or in the court of law after appearance. And if the case is non-bailable, then we have to apply for the anticipatory bail in the high courts. And if the anticipatory bail fails, then we have to appear before the court until the charge sheet is filed and fight upon it. This is the regular procedure for criminal courts.
Okay, sir. Thank you. We have another question from Dr. Vasuprada. In a case when the doctor is proved innocent, can the doctor file in turn a case for defamation?
Definitely. He can go for criminal defamation and civil defamation. Both he can pursue. In criminal defamation, he can sue or file an FIR against the person who has defamed the doctor. And in civil litigation of defamation, he can go for the compensation of whatever amount he feels fit regarding the loss of his goodwill.
Okay, sir. Thank you. We have another question. Like if a negligence is being done by a paramedical staff in a hospital, then will be the consultant will be responsible or not?
Surely, definitely. This is the vicarious liability of the consultant. Whenever goes bad by the staff, whenever anything goes wrong in the hands of staff or any support staff, or even the associate doctors also, then the hospital or the person on whose the hospital is registered is liable to pay compensation. Not that staff is liable to pay compensation, because there is an employee and employer relationship or agent or principal relationship between them. So employee is responsible, not employer is responsible, not employee is responsible, and principal is responsible, not agent is responsible.
Okay, sir. Thank you. So if a surgeon or any doctor did the surgery in place away from doctor's place or out of the state, and if any complication arises to patient, will doctor will be held for permission or the respected hospital will be held for this punishment?
That hospital itself.
Okay.
But
So
that
will
another doctor who is a visiting surgeon will also be a party in that case. But the first party will be that hospital.
okay, sir. So yeah, we have ended up with this question and answer session. So Prajakta ma'am, Priyanka ma'am, if you have any question, please you can ask.
So during the freelancing surgeries, if anything happens post-op, so at that time, what may be the things priority taken by the surgeon who has operated and with that hospital, and that mostly happen when we do the freelancing surgeries.
Mm-hmm. Then who is liable to pay compensation, or who is liable for medical negligence? This is the gist.
Yes.
Okay.
The most of the time, laparoscopic surgeons, we do freelancing sometimes. Means we used to go somewhere else, we operate there, we come back. But after a post-op or 2 to 3 days after, if some mishap happens, at that time, and if that negligence happens or something like that, whatever it is, but how we should protect ourselves in such cases, because we just went there for the operative purpose only. And
there are
later on, means what are the laws for the freelancing surgeons? Means how they should protect themselves.
There is no any codified law regarding the freelancing surgeries, but I would say that there are two parts of this question. First is who is liable to be held negligent. Then primarily the hospital is liable to be held negligent, or liable to pay compensation or be sued. First. Second, there are three parts. There is pre-op, there is proper operative procedure, and post-op. If there is any negligence regarding the operative procedure done by the freelancing surgeon, then he may be held guilty. He may be, or she may be. But anything happens after 2-3 days, and there is no direct linkage between the procedure done and the end result of that bad result or the negligent act which has been alleged, then it can be construed that the post-operative care which must has to be taken by the hospital, it is not been taken, and the hospital may also be held like negligent. But if anything happens on table during the surgery by the hands of a surgeon, then that freelancing surgeon will also be a party to that case. He will not be spared. Hospital is first liability. If anything happens on table, the hospital is first liability, and second liability of that operating surgeon.
Okay. And if later on some complications occurs, which may found that this happens due to, means the procedure was okay, but later on some infections or something that happens to that.
Surgeon has nothing to do about that. He is not liable to pay, or he is not being liable to be guilty.
Okay, but that should be proved that it happens later on or during the procedure.
Yes, yes.
So that should be proved at least.
That should be proved. That should be proved by the documents.
And so most of the times, what we people face problem that during surgery, if like PPH, while we are operating for a PPH condition. So at that time we are like means on our toes and everything was means quickly done. And most of the times we do not document such things. Even not for anesthetics was in his helping mode to do everything, and surgeon in other things. So how to document when we should if at that time, if suppose patient dies or something happened later on after 2-3 years, how we should maintain our record, when we should hand over this record to the police, and what time we should get, or what legal method is there that we can write properly, and then we can later on hand it over to the police.
See, this is very multifactorial question. First is, if you are talking about PPH per se, then PPH is an emergency procedure. So for emergency procedure, it is not mandatory that every time you should document everything on time, on that particular time. You can document it afterwards, first thing. Second thing, if patient has any issues regarding the procedure, or if he wants to be, what we say, any trust issues he is having regarding the procedure, let him do post-mortem examination of that patient first, then hand over the body after post-mortem if they want to make a chaos. Second. Third, when to give the documents to the police? When they are asking you in writing. Okay. Then you have right to say that I will hand over the documents after 2 days, after 3 days, whenever you are comfortable with. You have right to say to the police, police cannot seize your documents anytime. They have no right to seize your documents. They will ask you for documents in writing. You give the answer in writing. I will hand it over after 24 hours. We will rectify all the notes. We will flourish all the necessary information, and then we will give Xerox copies certified by our stamps, and the Xerox copies will be handed over to the police, not the original documents.
Okay, so original document should be kept with us.
May not, if they are asking for an original document, let them get the court order.
Okay, so we should, when they ask us for the original documents, we should ask them for the court order.
It's not mandatory to give original documents, because our law says that we have to retain our IPD documents for 5 years.
Okay. Okay. Next question, Prajakta.
Yes, in this I wanted to ask, some patients want Xerox of IPD papers. So in medical legal cases, that also requires a court order?
No. They have right to ask for the Xerox copies of day-to-day
Okay.
treatment.
Okay. And I wanted to ask another question. What are the laws when we are referring patient from one hospital to another hospital and some complications occur in the transit, for example, in the ambulance? So, any laws, who is liable in that case?
This is very tricky question. It's very difficult to answer because it will depend on the facts and circumstances of that case. Firstly, if you will
I think in that
patient,
case,
then there must
we should take
be
precaution. That means if you are referring to patient, if patient is bad, then you have to go with the patient. Means if someone, RMO or well, you should send someone with that patient, taking all the care till he reaches towards the another hospital. Like means what in my experience, like we usually do that thing. Like means if someone is very serious and we need to refer this patient, then we have our team or our sister and one RMO that they will go with that patient until they reaches to the another hospital, and they will take care of if anything goes wrong. They will at least do something and they will try to give something so that we can defend ourselves.
there are two things we will have to ensure that. First is our papers. Before referring the patient, we must be well documented that patient was referred in time and with the proper indication that the patient had to be referred. These two things must be mentioned on our papers, and referral letter must be well acquainted or well fulfilled with the necessary information for that particular hospital, and the copy of referral letter with signature or thumb impression of relative of the patient must be written in the hospital. These two things must be taken care of.
Yeah. Thank you, sir. I have one more question. So this is very specific. So Usherman syndrome is a complication of DNC, which we see in our OPD also, but that is diagnosed quite late after the procedure and mostly by other doctors. So this is a very late complication. So regarding late complications, like for example in DNC, not necessarily every time, we mention that, Usherman syndrome is a complication. Not even on consent, these things are mentioned. So what are laws regarding to such complications?
No, this is the scar formation. I think, as per my knowledge, this is the scarring of the uterus, Asherman syndrome.
Yes.
Am I right?
Yes.
So these are the regular complications of any surgery. So ideally, it should be mentioned in the consent form. If we are talking about the informed consent, then we have to note it down in the consent form.
Okay.
See, the two things are very clear. The remote complications, or which are not likely to happen, these complications may not be included in the consent form. But at least which are very frequent complications, they should be named in the consent form. This is the thing.
Okay, sir. We have one more question in the chat box. In the case where the employer would be held responsible, what would be the fate of the doctor or the paramedic who made the mistake in the first place?
There are two things. If there is a government hospital, they will have an internal inquiry about that, and they will reprimand that staff or employee for that whatever mishap happened in the hands of that person. And if it is a private institution, then God saves him.
Okay, thank you, sir.
In private institution, there is no rule. If they feel that he is not competent to do certain work, they can fire him or her. They can levy or cut his PFs and collect that amount of compensation from his PFs. They can do anything.
Okay, sir. And what about legal action on that paramedic?
Legal action, see, it is up to the party who alleges or who has filed the complaint. That institution can sue that particular person for that thing. No problem at all.
Okay, so we have a follow. Yeah. Yeah, we have a
Any
follow-up
further
question.
questions?
Yeah, we have a follow-up question after the same question is, will the doctor's registration be suspended?
If the party reaches to council and the disciplinary action committee of the council feels that the doctor's registration must be suspended, then the registration may be suspended. But that party must reach to the ethics committee or the ethics and regulation committee of the council. And if the council feels that there is a what we say negligence on the part of doctor, then they may reprimand him, they may cancel his or suspend his registration also.
Yeah, thank you, sir.
Any further questions? Abhishek?
Yeah, there are no new questions in the chat box now.
Okay. So we can conclude.
Yes, ma'am.
Hello.
Dr. Aarti, Dr. Abhishek, kindly proceed with the vote of thanks.
Dr. Abhishek?
Hello.
Dr. Aarti, Dr.
Prajakta
Abhishek.
ma'am.
Yes, you're audible,
Hello.
dear. You're audible, dear.
Hello.
Yeah,
Prajakta
proceed.
ma'am, can you hear me?
Yes, yes, dear. I can hear you.
Yes. Please proceed, Aarti.
Thank you,
I
Prajakta
think
ma'am.
some. Yes, carry on.
Yes.
Aarti, please.
Yes. Thank you, Prajakta ma'am, and Priyanka ma'am, and Dhananjay Kulkarni sir for this wonderful question and answer session. On behalf of NIMA OBGY Society, I would like to express my gratitude to NIMA OBGY Society Central Officer, BRS Dr. Kamini Diman ma'am, Dr. Priyanka Nakade ma'am, Dr. Vishnu Bhavani sir, and Dr. Rajesh Uttani sir for their guidance and support to conduct today's webinar. I would also like to thank and extend my gratitude to our eminent speaker, Dr. Dhananjay Kulkarni sir, who took time from their busy schedule and delivered very knowledgeable and wonderful session with us. Thanks to all NIMA OBGY office bearers. I would also like to thank Dr. Girish Daga sir and Dr. Prajakta Patil ma'am for all the help and guidance for technical support. Last but not the least, I would also like to thank from bottom of my heart to all the delegates for their participation. Without all of you, this webinar would not have been possible and successful. Thank you for all attending and hope you all have learned and gained immense knowledge from today's speaker. Wish you all a wonderful evening ahead. Now, with due permission of all the dignitaries, I'm concluding this webinar. So thank you so much. We will meet in our next webinar. So thank you.
Thanks a lot. Thank you so much. Thank you so much, sir. It was really wonderful webinar.
Thank you, ma'am. Thank you.
So meet you soon, sir. We again want to listen from you. So in the next episode, definitely we will with the new subject, with the new medical laws for all our. Yeah. Thank you, sir. Thank you so much.
Thank you so much. Thank you.
वीडियो पे नहीं दिखा